ready in just a moment. We're going to swear you in and we're going to proceed to the hearing.
Okay, thank you.
Okay, we're ready. Parties, if you would please raise your right hands. Do you swear or affirm that the testimony you're about to give will be the truth?
Yes, ma'am.
Okay, Ms. McMillan, you swear to tell the truth?
Yes, I am.
Okay, thank you, ma'am. We do have service, so the court has gone through the file. So let the record reflect that on behalf of Cash, Mr. McMillan has, Mr. Ronaldo has submitted paperwork with regard to a loan. And stand by. Court is in receipt of and is looking at paperwork submitted by Mr. Ronaldo on behalf of Cash Now with regard to a check that was recently submitted to Cash Now payment in the amount of $398.61. And subsequently, that particular loan plus $28.66, which is as a result of return item fee when Cash Now submitted that check for payment to the bank. So subsequently, stand by. The court's going to take a look also at the filing. Also, let the record reflect that on behalf of Cash Now is suing, seeking treble damages pursuant to Michigan law, which actually increases the dollar amount of their claim. And we can proceed from there. Mr. Ronaldo, on behalf of Cash Now, again, if you would please, your name, because we're on the record, not on the record, but we are streaming live, and we are entering into the hearing phase of the case at this time. So your name, please, and your position with Cash Now.
My name is Michael Ronaldo, and I'm the owner of Cash Now X LLC.
Okay, and it is the case that on behalf of Cash Now, you are seeking treble damages?
Yes, ma'am.
Okay. In addition to the information that the court is in receipt of, specifically, the court is reviewing a photocopy of the original check, and also a letter from Cash Now to Ms. McMillan from May of 2020, seeking the original, seeking recovery of the original dollar amount of the loan, which is $398 plus $28.66 for a return check fee. Ultimately, at the time, Cash Now was seeking repayment of $427.27, which was the dollar amount of the original loan, plus the return check fee. Has anything changed since then, or is there anything new that you wish to add?
No, ma'am. No payments have been made or anything, Your Honor.
All right, thank you. Is there anything further on behalf of Cash Now?
No, ma'am.
Okay. Ms. McMillan, you've heard testimony from Mr. Ronaldo on behalf of Cash Now. Is there anything at this time that you wish to present by way of testimony, or anything that you wish your response?
Yes, I'm gonna pay him as soon as I can. I'm getting my taxes. As soon as I get my taxes, I'm gonna pay him off.
Okay.
I'll make a arrangement to pay him.
Okay, well, here's what we're going to do, ma'am. Rather than set up a timeline where it could cause difficulties, again, okay, because the court recognizes that you're indicating that you would wish to pay him once you receive your taxes, which would be sometime after April. Rather than set a timeline, that what we could do is simply enter a judgment, which would open the door for you, ma'am. It gives you 30 days in which to pay it. But if it does not happen, which you can always do then, is contact the civil division of our court and file paperwork to make arrangements for a payment plan for installment payments. okay?
All right. I appreciate.
Okay, that's fine. So here's what the court is going to do. The court is going to enter the judgment.
No.
Plus court costs. Stand by.
Wait, I can try to remember.
The total dollar amount of the judgment is $1,304.59. And again, that does provide you, Ms. McMillan, with 30 days in which to pay it. And then, but also in the meantime, there would be an opportunity for you to contact the court, the civil division of our court, to make arrangements for installment payments. And you will receive.
I would like to make payment plan.
Okay, well, that'll be an opportunity. Once you receive your paperwork, you will contact the court and be able to do that.
Okay.
Okay, so here's what we're going to do. Be advised, what the court is going to do right now is just make sure that we have a good mailing address for everyone. Be advised, we are streaming live to YouTube. We're mindful of making sure that we're not publishing anybody's personal information. So the court is simply going to ask for confirmation of partial of your partial address, not a full address, because we don't want anybody knowing your personal business. So we're just going to confirm that. Okay, so stand by. On behalf of Cash Now, we have a 13720 address. Is that still good?
Yes, ma'am.
Okay, and Ms. McMillan, again, we're not going to give your full address. We just want to confirm, is the 15025 address still a good address for you for receiving mail?
Yes. Yes.
Okay, okay, thank you, ma'am. Then we're going to make sure that you all get that information. And Ms. McMillan, receive this in the mail and keep it for your records. So in case you ever need to contact the court or anybody else regarding what happened today, the paperwork that you get in hand is what you're going to want to have in hand as a reference in case you need to contact the court and talk to anybody about what happened today, okay? Also, even though Zoom has kind of created a little more informality, the court is still wants everyone to know that if either party is dissatisfied with today's result, they do have an automatic right to appeal this court's decision within 7 days of today's date. And again, we're going to make sure that everyone gets copies of their paperwork. At this time, we are concluded. I'm sorry, before we end anything, on behalf of Cash Now, is there anything further with regard to Ms. McMillan's case?
No, ma'am.
Okay, Ms. McMillan, before we let you go for the day, we appreciate your patience. Before we let you go for the day, is there anything else before we're done with your case, ma'am?
No.
Okay, thank you both for your time. I appreciate your patience. And again, Ms. McMillan, we're going to get this in the mail to you, okay?
Okay. Thank you.
Okay, thank you, ma'am. Take care. Okay, and it is now 6 minutes to 10. Okay, Eddie Davis and Bernisa Davis, we still don't have an update for you guys. What we typically do is wait until closer to 10:30 because again, because of the extra elements of Zoom and people maybe, everybody's at different levels of their levels of technology savvy. We try to give people opportunities to contact the court. So again, there's no thing, you just sit tight, you're doing great. You have time to maybe grab a cup of tea or something like that. We typically wait until about maybe 10:30 because the court is scheduled to start at 9:30. We try to give people about maybe an hour of wiggle room to, to hash out opportunities to get into the Zoom room. And once we have an update, we'll let you know. Okay, so just sit tight. Thank you both.
Thank you so much.
Patterson, sir, way to turn off the fan. Thank you. Glenn? No, but we'll give it a try.
Okay, now,
Well, the thing is, we got these up, so it's like, let me ask you this. Is it possible to move? I can help you move it. If there's a way to move it, I don't know. No, maybe. Maybe, or here.
needs movement.
Would be too much to move it.
No.
You can try it, or nothing, or here, either way. Just gonna make it very easy.
See, I have no fancy plug.
Gonna have to do that, use that, and see if Thanks, sir. Hi, we got someone checking into the room. Okay, we're waiting for you to get into the room. Thank you. Okay, hi, Anthony Ephraim?
Yes.
Okay, also, if you could please, if you have video capable, please turn on your video. Okay, sir?
You say put on my video if I have what?
If you can turn on your video, sir, so we can see you. Can you check in? What case are you
Oh,
checking in?
okay. Let me see how to do it. Hold up. Hmm. Um, hold on.
Okay, Mr. Ephraim, while you're working on that, are you checking in on a particular case, sir?
Yes. My case number is 203-49805.
And you're Anthony Ephraim? That's the name, that's the person whose case you're checking in on?
Yes, this is me.
Okay, let me ask you this, sir. It may depend on which courtroom you're trying to check into. Do you know which judge or what courtroom you're checking into, sir?
Yes, my camera working now. 433, room 433, Judge Patricia Penny Milder.
Okay, well, for courtroom 433, you're actually dialing into the wrong courtroom. So you're doing, procedurally, you're doing everything right. So you did get into a courtroom, however, you dialed into the incorrect courtroom. So stand by, let's get you a better number to dial in, okay?
Okay.
Stand by.
And dial 313-965-2401.
Okay, that's the number for the courtroom, sir. So we're gonna disconnect you from this Zoom room. Use your phone to dial into that courtroom and let them know that you're trying to dial into courtroom 433.
Okay, it's 965-2401.
That is 2401.
And then let me give
Okay.
Stand by. Maybe we might have some more information for you. Stand by.
Okay.
me 1 second.
Stand by, sir.
Okay.
Okay, in the meantime,
You might have to call that number.
just call it.
Yeah.
Okay, Mr. Afford, we thought we were gonna have some additional information for you. Dial that 965-2401 telephone number, and they'll get you the correct dial-in information so that you can dial into that room, okay?
Okay.
Okay, thank you, sir.
Thank you.
Yes, sir. Okay, we have a Kennedy party checking in. If you can unmute and also turn on your video, if you have that available, please, as we get you checked in. Hi, your name, sir?
My name is Kennedy Marshall with Trinxa LLC.
Okay, gotcha. Okay, we do have a party here, checked in with you. And what is your name again, sir?
Kennedy Marshall.
Okay. Okay, sir, it is the case that we have one of your parties that has checked in, so here's what we're going to do. Given that we have the opportunity of Zoom capability, if it is the case that the parties would like to make use of a breakout room, we can do that if you all want an opportunity to see if there's a way to resolve the case. But it would be the case that both parties would want to participate in a breakout session to discuss the case and see if they could work something out. The alternative is we could proceed to hearing. So, Mr. Marshall, this is your case. So how would you like to proceed?
I'm open to a breakout.
Okay, and on behalf of the Davises, if you can turn on your microphone. If the Davises can turn on their microphone. Okay, hi. Okay, hi. On behalf of the Davises, the court was addressing both parties, but with regard to Mr. Marshall, if everyone is open to doing it, we can create a breakout room for you, which will give you an opportunity to discuss the case and see if you can work something out. If you're both open to doing that, the court can set up a breakout room for you if you would like to do that.
Yes, yes, we are.
Okay, all right, stand by. Bear with me. If for whatever reason I accidentally put you out the room or I end up exceeding my techie capabilities, just hang on, dial back in if anything goes wrong, but otherwise we're going to set up a breakout room for you, okay? So stand by.
Okay.
Everybody stand by. And I think there's gonna be an invitation or information to join the breakout room.
Yes, okay, and we're gonna select it now.
Yeah, go ahead, thank you. Okay, on behalf of Patch Now, here's what we're going to do. We get a decent bit of time. We don't have anybody checking in. Just be advised that in the, Mr. Ronaldo, that in the event that we do have parties that join us in the meantime, we'll certainly give them an opportunity to do that. But in the meantime, what we're gonna do is see if we can't go through some of your cases at this time, because we're about 10 minutes, about 11 minutes before the 10:30 hour. So again, if anything develops or if anybody checks in, we'll certainly revisit any of those cases. All right. You're still sworn in, sir?
Yes, ma'am.
Okay, the next one that we have up is, actually, we have Cash Now 10 LLC with Darius Hatcher. Although it appears that it's on the docket. A couple of things. Were you able to finish, were you able to get service on them? Because be advised,
Yes.
just so you did get service?
Yes.
Okay, also, we do have a register of action or a note in the file indicating that, did you also submit any proofs or evidence for the case?
Yes, I did. I emailed them a few days ago, and Pam Holland had said that she had gotten them.
Okay, we may have to set this one aside and see if we can get some updates, because the proof of service is not in the file. So we need to get an update on that as well as evidence. So I'm gonna make a
Oh,
note
so
of-
no evidence came through on the email either?
Oh, that's correct. So we don't, but here's the thing, that's not to say that if we did get it, just didn't make it into the file. So we need to
Right.
we're gonna contact our civil division and get an update, so stand by on that one.
Yes, ma'am.
Okay, the next one that we have is Cash Now 10 LLC versus Norman Andrews. And we do have, evidence that you submitted. We have the proof of service, so good on that one. We can proceed on that one in the meantime. Again, you're still, service is good. And with this particular one, you're seeking $371.27.
Yes.
Correct?
Yes, ma'am.
The court is in receipt of documentation regarding the original loan. Also, the information regarding failure to repay.
There's no, 540 up here. What we call it now. Service for this case. Two, one, 2, 4, 0, 0, 6, 3.
Okay, the next case that we have, it's like Donna Stotts. And we do have
Stats.
stats, okay, and the court is in receipt of the evidence you have submitted with regard to the original dollar amount of the loan that was not repaid. And you're seeking trouble damages from an original action date of December 4, 2019.
it up to cash now, so.
Yes, ma'am.
Counselor, this is for-
And Your Honor, just, I hate to interrupt you, but all of the evidence for all these cases this morning were all submitted at the same time. So I'm sure the very first one just got misplaced or whatever. But I know Pam and I specifically talked about Norman Andrews and a couple other ones. So it's there somewhere. If not, I can forward the email directly to the court if you want, whatever is good for you.
Well, sit tight, Mr. Sanford, you want,
Yes, sir. Hold on one second. I'll call you back.
stand by.
Yes, sir.
Oh, I'm sorry. He was saying that he submitted all the evidence for all of these right about the same time. If it's possible, if there's an email address, we can go ahead and
You can send it to me. You can send it to me, that's fine. It's tough to-
Just go ahead. Okay, Mr. Ronaldo, we're gonna have you send it to our clerk because he's sitting right here, so he'll be able to receive it in his inbox. So just stand by. He's gonna give you the email address, okay? Let me know when you're ready.
Okay, I'm ready.
Okay, it's Aaron, Aaron .Sanford, SANFORD at
Mhm.
36th District Court.org.
All right, and that is for Hatcher, 6-3, last one, correct?
Correct.
Yes.
Okay, all right, let me do that right now.
And also, if you have the proof of service, that would be helpful as well, along with the evidence packet.
Yep, they all went together, so I'm just forwarding the email that I'd already sent to.
Fine, thank you.
You're welcome.
You want that one back?
Okay, the next one that we have is Patch Now 10 LLC versus Andrea Worthington. We do have the evidence and we do have proof of service. Court does.
Your Honor, I'm sorry, Your Honor, to interrupt you, but did we ever finish up with Stats case ending in 6-5?
Yes, just finish that one.
Okay, I'm sorry, thank you.
No, as, we were kind of doing a couple of things because, court moved on to stats. At the time, we were also kind of having a cross discussion about getting proofs for the Hatcher case.
Okay,
So with regard to the Worthington case, court is in receipt of evidence with regard to the original, basis, for the claim, with regard to a check, where there was, the other party did not, complete payment on the check. We do have service in the file. And the basis for the claim arising from October 31, 2019, for $1,392.49 plus the court costs. Okay, next we have Cash Now 10 LLC versus Khalil Roby. We do have service. And court is in receipt of paperwork for the basis for the claim, the amount of $565.61.
Your Honor, I hate to interrupt you, but I think Roby is supposed to be for 2 o'clock.
Ah. Oh, thank you. No, we just ended up, okay, we ended up with a stack of all of them at one time. Got it, that's fine.
I just wanted to give Mr. Roby time to show up.
That's fine. Then the same thing, okay, Bird, not we're just gonna bundle them all. Barrett.
Yep.
And, okay, and actually, since we're talking about it and you're here, looks like we do have everything, well, either way, we have everything for Roby ready to go. Everything for Bird.
Did Mr. Sanford get my email?
Let's see.
He's about to check.
Okay.
I have not received it as of yet.
Hasn't come through just yet.
Okay. Can Mr. Sanford recite his email address again? I just want to triple check here.
Okay, it's AARON period SANFORD at
Okay.
36th districtcourt.org.
Yep. And when you say Sanford, is that with N as in Nick?
Yes.
Okay. All right. I've sent it once at 10:26. It said it went through, and I'm gonna send it to you again, just to be on the safe side.
There it is.
He's got it.
Okay, good. All right, good. You're welcome.
Okay, thank you. Court is in receipt of the proof of service, and we do have the paperwork regarding the Hatcher case. The original basis of the claim was for $342.61 plus court costs. Court is satisfied. Okay, and I think that is everything we have with you for, at this time, for this time slot. The rest of them are at 2:00, correct?
Yes, ma'am.
Okay, we do have four, okay, but so 4 cases, we have paperwork for everything, so if anything, we're all set for now. Email, the mailing address you've already got, and we'll see you at 2:00, okay? We'll see you
All
at 2
right,
o'clock.
we'll see you at 2:00, ma'am. Yes, ma'am.
Thank you.
Thank you.
Say it again.
Is that restricted? It says, close, you know, here it says closed, so they get paid or something?
They have, you take them.
Yeah, just, I mean, I just haven't opened up the deal with, you just close it, and touch it, so I don't know what we. I don't know what we're doing.
Civilian mail, it was closed on the 24th. Looks like Boyer heard it.
Oh.
Somehow.
Like we would, like we would.
Went to informal hearing.
I can't touch it, it's been due for it, so we don't feel like we can do it.
Okay.
Okay, if you don't mind, if you can print that out, then I'll just.
Wait a minute. Was I on Boyer this week?
Hmm?
What's this? Okay. Okay, I see. We told them that they were ineligible for online plea, and they went to civilian mail.
But they ended up having. It's like.
Yeah. It was from the Warrior
It was an accident.
on 24.
Actually, it would have gotten dismissed, there's nothing to it. Because the trigger didn't appear.
I still sad. Yeah, you must have said ineligible for online plea set for informal hearing. So I said informal hearing, then they went on to 24.
224.
Right, and then they,
Dismissed.
right, and then they did the civilian bill at the same time. Before on the 19th, they probably tried to handle it that way also.
Which must be this.
Right, so, but they already addressed it.
But it's already been
But this
dismissed.
is,
There's
it's
nothing to
already,
do.
yeah, so it's not to do with that.
Okay, hi, court just looked up and saw that there was a notice. Was there something we can assist you with? Can't hear you, Mr. Kennedy. Can't hear you, Mr. Kennedy. Uh-oh, hang on. All right, stand by. Okay, Ken the Davises, can you hear me? Mr. Kennedy, can you hear us? Tell you what, I think we're gonna have to close this breakout room. We're gonna close the room.
Okay, there we go.
Okay, I think we returned everybody to the main session. Okay, I think there was an audio issue. I wasn't sure if everybody could hear us. It is the case that, I think somebody said that they needed assistance, so that's when the court entered into the room. Mr. Kennedy, be aware, we weren't able to hear you, so I don't know if that was part of the issue. Can we all
Yeah,
hear
we
one?
couldn't hear. I'm sorry.
That's okay, so I can hear you now, Mr. Kennedy. Davis, can we hear you? Can you hear us?
Yes, we can hear you.
Yes.
Okay, thank you. Okay, let me ask you this. There may have been concerns, I mean, there might have been some techie issues with the breakout room. Were you all able to make any progress, or what's the status now, Mr. Kennedy?
Yes, we were able to make progress and come to an agreement.
Okay, great. All right, tell you what, Mr. Kennedy, this is your case. If you want to kind of just flesh out what the agreement is, and then we can do a consent, or just let us know how we're proceeding, sir.
Okay, right now at this time, we've agreed that if the Davises are able to vacate the property by April 1st, we would dismiss the case. If they're unable to vacate, then we would ask that we go into a default judgment.
Okay, well, it won't be a default. I mean, presumably everybody will come back on April, you said April 1?
April 1st is the date, yes.
Okay, here's what we're going to do. The court is going to do an adjournment, which means that keeps the case afloat.
Okay.
And we'll all come back either on April 1 or close to. Well, actually, we're going to set it for after April 1, so in case there's anything else that needs to get addressed, everybody kind of knows what they need to address after April 1. So let's take a look at the calendar. Okay, April 1 is a Thursday. This court hears cases on Friday, so here's what we're going to do. In the event that the dust is still flying, where people are still busy, we're going to push this out to April 9, which is a Friday. So that'll be 1 week after, a week and a day after this deadline that you all have set. Okay? So 9. Okay, stand by. Yeah, we're going to set it again for 9:30. Okay, here's what the court has written down. There's going to be an adjournment to April 9, 2021 at 9:30 a.m. to allow the parties to complete conditions agreed upon, specifically that the Davis party will vacate the premises by April 1, 2021. Okay?
All right, thank you.
Thank
Okay,
you.
so does is that keeps the case afloat. Nobody has to do anything special or different. Just go ahead and complete what it is that you all have agreed upon. And if by the time we get around to April 9, 2021, and nobody's checked in or we don't hear from you guys, then what will happen is this court will just go ahead and dismiss the case. So nobody has to do anything special or different, okay? It's just that this keeps everything status quo and afloat, so you don't have to do anything extra. Just go ahead and concentrate on fulfilling these conditions, and we'll go from there. Also, however, one other thing is, because here's part of the question, in order for the Davises to receive your paperwork, we have to do a couple of things. We might have to give you guys our telephone number because one, we're going to mail you your adjournment, so we want to make sure you get your paperwork for today, okay? And secondly, if it is the case that there is going to be a dismissal come April 9, we're going to need a mailing address or someplace where you can receive your mail so that you get all of your paperwork, okay? So we don't want anything getting lost in the shuffle. So here's what we're going to do. We're streaming live to YouTube, so we're not asking you to give your personal information. We're going to give you a telephone number to call into the courtroom, okay? You're going to speak to our clerk, Mr. Sanford, and you can give him the mailing address for the adjournment today, and also if it's or an address for after April 9 in the event that we dismiss it and we need to mail your paperwork. So there might be two addresses. You got to let us know, but we need to make sure you get your paperwork. Okay, so stand by for the telephone number.
Okay.
The telephone number is 313-965-2568. Again, that's
67.
I'm sorry, 965-2567. I'm sorry, I misspoke. 965-2567. So
Thank you. We have it.
Yeah, please call the courtroom and we'll get a mailing address for you, whether it's going to be two addresses or one, but we just need to know where we can send you your paperwork for everything, okay?
Okay, thank you.
Okay, so again, it's going to be April 9, 2021. And Mr. Kennedy Marshall, is there anything further before we're completed with this particular matter?
Not this particular matter, Your Honor, no.
Okay, thank you, everyone. We appreciate your patience for your participation. And again, if the Davises can give us a call. I mean, I don't know if you need to be removed from the room, that's fine in order to call, but at some point, just don't wrap up for the day until you give us a call. We need mailing addresses for you guys, okay?
Yes.
Okay. All right. And I do have one more question. So, and there's still also, there's the upcoming date of March the 8th. Is that still in effect as well for the hearing on March the 8th?
Okay, the court is not aware of anything on March the 8th. Is that landlord tenant?
Yes.
Okay, well, here's the thing, keep that date. Because if anything does develop here, well, here's the thing, and just to be clear, guys, Mr. Kennedy and Mr. Marshall, you're kind of jumping ahead of yourself because technically, this case should not happen until you're done with landlord tenant.
Okay, and just for clarity, Your Honor, why is that?
Because landlord tenant takes precedent over that. Not only that, but small claims is there's no basis or the case is not right. There's a legal concept called ripeness, which means kind of like the way you wouldn't pick a fruit off the vine or off a tree until it's ripe, until it's ready. Okay? Small claims, there's no jurisdiction for this court to have, this court doesn't have jurisdiction over a type of case like this if it's landlord tenant until the lease is truly over and the landlord-tenant relationship is truly over. If the Davises are still residing at this property, and assuming what we're looking at is where they're living right now, and this is the as a result of the lease agreement between the parties, this case is not right. In other words, you can't bring both at the same time, or small claims cannot happen before landlord-tenant. They have to be out of the property, because here's the thing. In reality, Mr. Marshall, you don't know what your damages are to the claims until they're out of the property and you fully reclaim the property and you fully know what the damages are. So here's the thing. If it's the case, okay, on the Davises, when is the landlord tenant case?
I'm sorry, what was it?
Davises, when is the landlord tenant case again?
It's March the 8th.
Okay, here's what we're gonna do. We're actually gonna push this out past March because we need to know what's going on with the landlord tenant case. So, Mr. Marshall, be advised, sir, technically, this case shouldn't even be happening. I'm not saying that there isn't a basis for the claim, it's just that you have to take it in proper order. First comes landlord tenant, and you filed that, that's fine. Because arguably, this case is not right. This should not proceed until after the landlord tenant case is over and the judge in that case determines what's going to become of the lease agreement, the landlord tenant relationship. It is not until the landlord-tenant relationship is over that the plaintiff, in which case the landlord, being Mr. Marshall, could file his case in small claims, because that's to protect both parties. So here's the thing: it benefits. There's a benefit and a responsibility on both sides. It isn't until landlord-tenant is determined whether it's to regain possession of the property, whatever it is for. This court has no information about what that case is about. We're not going to discuss it here. But just be aware, and this is on both sides, that small claims does not proceed until after landlord-tenant is over, because landlord-tenant, whatever the action is going to be, that determines what's going to become of the lease agreement. If landlord-tenant, if the judge in the landlord-tenant case says, okay, the lease ends now, in that landlord-tenant court, then, Mr. Marshall, you are in a position to file your small claims case, because then you can determine what your dollar amount is for damages.
Okay. And I hear you, and I guess just ironically in a situation where the maximum is $6,000 and we've exceeded $6,000. I know this is a rare situation due to the eviction moratorium that occurred last year. That I guess is unprecedented to my understanding, where the back rent exceeded the amount of maximum amount that we could request. So
here's the thing. Short answer is, again, this court can't speak to the moratorium, so I don't know how the moratorium affects it, but the dynamic normally, the landlord tenant, and then subsequently small claims works this way. If it is the case, based on what you're saying, the dollar amount in small claims you're exceeding $6,000. $6,000 is the cap. That's the cap in small claims. You can still keep your case and pursue damages in 36 District Court. It just won't be in small claims. You can go to the General Civil Division.
Okay.
General Civil Division is for a dollar amount where the amount of damages alleged is over $6,000. So you max out at $6,000 in small claims. So here's the thing. If at this point, again, this court cannot give you legal advice, you need to speak with an attorney, you need to speak with somebody. But procedurally, the court can speak to this extent. If it is the case that even as of today or at the time that you filed this case, you max out at $6,000. Or if you anticipate by April 1 or April 9 or whenever in April, you will have exceeded $6,000, then you can file this case in in the General Civil Division.
Okay.
So you can still pursue it, because otherwise you're shortchanging yourself. So again, it kind of loops back to what the court originally said. Nobody knows what the amount of damages are alleged until they vacated the property. You don't know where you stand until after they're out of the property, and you can fully sit down and assess what, if anything, are going to be your damages.
Okay.
See
No, I follow you, Your Honor.
Okay, so here's the thing. Given one, the parties are not out of the property, this case is not right. Plus, if it is the case that you're suggesting, and again, court can't answer those questions, if you're suggesting that either now, as of today, or by April 1, they will have exceeded you would claim $6,000 or more, then it is more appropriate to bring this action in the General Civil Division. Now, if you were to do that, you still have to serve them because it's a new case. Same set of circumstances, same parties, same lease agreement, same everything. but you still have to serve them again in the general civil division,
Okay,
okay? So you still have to get service, because the thing is, you don't know where you stand just yet until you get possession of the property again, and you fully assess, okay, where am I now?
Yeah.
Okay, so here's the thing. Bottom line is, this case really should not be happening, okay? So the most appropriate thing actually would be to dismiss this particular case. Do what you're going to do, whatever the parties are going to do, and handle whatever you're going to handle in landlord-tenant. And then everybody can assess where they stand as of April 1, but then after, beyond that, we don't know what's gonna happen until after that March date in landlord-tenant.
okay. Well, Your Honor, saying that the March date is occurring prior to the April date, can we keep the April date on the file for this adjournment?
Well, no, because here's the thing, this case should not be happening, it's not right,
Okay,
bottom line.
So
So
in
I-
that case, Your Honor, may I speak?
Go ahead. Go ahead.
Oh, in that case, Your Honor, so since the case is not done correctly, so what we're saying is, should we just adjourn this case for March instead of April?
No, because here's the thing. Because the landlord-tenant case exists and you have a date in March, this case should not be happening anyway. It is too early for any action to be happening on this case.
Okay,
It is not right.
okay,
Right PE, right, so like a piece of fruit. I'm not saying there isn't a cause of action, but the bottom line is, by both cases having been filed too close in proximity to one another, the landlord-tenant case needs to happen first. Period. Then, if it turns out that this case this court will have jurisdiction for small claims, then Mr. Marshall can proceed in whatever way he feels is best as the plaintiff, if he's going to be the plaintiff in this case. So it could be small claims, or it could be in the general civil division. Because he brought up a point that if it turns out the dollar amount, whether as of right now or as of in March, whatever happens, if he finds that the dollar amount that he would want to claim is over $6,000, then he can file, but it would have to be in the general civil division. Right now, it's too soon to tell what's going to happen in small claims. He has no idea of what it is he needs to claim in small claims, because you're not out of the property.
okay,
Okay, now that is procedurally, this is not legal advice. The court is simply giving both parties an explanation of how things work procedurally, to the extent that this is what we have to do procedurally. Now, anything else, as far as what's going to happen, this court highly recommends that you guys avail yourselves of an attorney who can speak with you about your positions and what, if anything, you need to be doing on your respective, ends of the case.
okay.
Oh, and just for a question for clarity, Your Honor, just because I have to report this information back to another entity. I do understand the case is not right. I do understand the process of landlord-tenant prior to small claims. But I had a question in regards to potential damages, not necessarily damages, but what damages in the sense of, not necessarily damages to the property. This is a case where we're looking at unpaid rent for a certain amount of time, which has currently exceeded the maximum limit. Because of that, would we be eligible or able to file small claims without landlord-tenant, because that has occurred? As far as the rent rearage, would that be eligible to file into a small claims court? Or would it have to be something else contingent?
The short answer is no, because here's the thing. Again, you don't know how much is owed unless or until the tenants are out of the property. The clock doesn't start ticking, the money doesn't get counted, the damages are not assessed until the tenants are out of the property, period.
Okay.
You have no idea. Say, for example, heaven forbid, something happens, they don't move out until December 2021, now what? You see the point?
Yeah.
Small claims is not viable unless or until the landlord-tenant relationship is over, meaning that the parties are out of the property, period. okay? So again, sir, this court cannot emphasize enough, and this is on both sides, you need to, if this is what, and sir, I don't know what part you play in this particular LLC, USP Property Management, but the bottom line is that this is what you're gonna be doing as a business, you need to avail yourself of one, either get up to speed on what it is a landlord needs to do, the duties and responsibilities, and when you get to this stage, should it happen, you need to be prepared to deal with these things procedurally. Secondly, and/or avail yourself of an attorney who will be on hand to walk the business through how to do this. This court cannot give legal advice. So when it comes to damages, you're going to need to speak with an attorney or speak with somebody knowledgeable on what it is you need to bring if you're going to bring a case for damages, whatever damages is going to be. This court cannot give legal advice, but this court is only addressing the procedure so that everybody is more clear on what happens as of today.
Yes, ma'am. So Mr. Kennedy, what is your recommendation as far as, because I know that you will be taking this to the people that you're doing these proceedings for, what would you say would be your recommendation to them for this meeting on Zoom today?
I just kind of advise them as what the court said. The courts are currently saying, now, for clarity, Your Honor, is this case being dismissed or is this case being adjourned?
This case is being dismissed because procedurally, this case is not ripe. This case does not have jurisdiction unless or until the landlord-tenant relationship is over.
Okay.
And we don't stand until after your hearing date in front of your judge in March.
Okay, so I guess if I could answer Ms. Davis, at this point, I'll just advise them as the referee or magistrate just stated that this case is currently dismissed. We're going to proceed with the case on the 8th for landlord tenant. And then I guess pending what happens there, they'll want to proceed with the following case of suit or maybe a settlement during that hearing. Honestly, I can't say which way they will want to proceed at that point.
Right.
They may still keep the option open for things as we were talking about the original agreement. If you guys are able to vacate by the 1st, to kind of dismiss the tobacco damages, considering the things that are going on. Honestly, I can't for them. I'm just going to kind of relay the information over to them.
Okay. Once we get off of Zoom today, is there any way that we could call you to maybe see what we should, because of course we're still going to try to move, but we need to make sure that they are open to still having the same deal that they've already presented to us.
I'm pretty sure they'll still be open to that.
Okay.
As long as we can still come to the terms, I'm pretty sure they'll still be open with that.
Okay.
Okay, thank you all very much. The court really does appreciate your patience and your participation. Good luck to everyone. And again, Mr. Kennedy, Mr. Marshall, thank you so much. Again, convey this court's remarks to the people that you speak with. But the thing is, it needs to be in proper order. The court wishes everyone, well and luck. And again, Mr. Marshall, wherever possible, it would be advisable for the company for which you work to make use of an attorney or to just get more entrenched on procedurally what's the appropriate way to have their matters handled, okay?
Yeah, and most definitely, I think that it was just more of an issue with the pandemic, more so that kind of changed procedures from what we're normally used to doing. And then also a quick question, Your Honor, outside of this case, there were 4 other cases that were supposed to be presented today. I'm assuming that the defendants did not show with those cases.
Yeah, at this time, no one else is here. So hang on, let's double check.
Yeah.
That's correct. At this time, no one else has appeared, and the original date was for 9:30. So what we're going to do is, if we are concluded with this matter with the Davises, we can let them go for the time being. Oh, you know what? Oh, Davises. Have you guys called to give us a telephone number? A mailing address yet?
I'm going to leave the room now and go and call now.
Okay, make absolutely certain you do that, okay? Because you're going to want this paperwork.
Yes, ma'am.
Now, one question. Now, you said because everything's dismissed, then there should only be one address. Because originally you said there should be 2 one for
Well, here's
after
the thing,
April 1st?
because that was before the court became aware of the fact that was just about the time that we found out that there's another case. So here's the thing, bottom line is call this court, give us an address where you know you're gonna receive your mail, whether it's as of today or in March or whatever, it needs to be an address where you can receive your mail. Because you're
Okay,
gonna want paperwork, any other paperwork that you're gonna receive, you wanna make sure you get your paperwork.
I understand. Okay. And so as of right now, there's no address on file.
Well, here's the thing, we have whatever address is in the file right now, so whatever paperwork you have in front of you when you got served, that's the address we have in our current system.
Okay.
If, however, it sounds like if you're in the process of moving, you need to be able to get your mail, wherever
Yeah.
that's going to be. So what we're asking for is, if need be, contact the court, give us an address where you know you're going to be able to receive your mail between now and whatever comes within the next couple of 2-3 months.
Okay.
Got
I
it?
understand, Your Honor.
Okay, good luck, everybody, okay?
Thank you.
Thank you.
Yep. Okay, Mr. Marshall, back to you, sir. Okay, thank you again for your patience. The first one that we have is Friday Johnson.
Yes.
And tell you what, we didn't necessarily get sworn in. This was sort of like an extensive clarification of that particular case. So here's what we're gonna do, sir. We're gonna swear you in. Raise your right hand for me. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
And again, your name, sir, and your relationship to Trixa, DBA USP Property Management.
I am Kennedy Marshall. I am a property manager here at Trinity USP.
Okay, and you did submit paperwork for the Johnson case, including the lease agreement. Did we get your proof of service?
For Ms. Johnson, the first attempt was failed. We're still trying to reach out to serve.
Okay, well, here's the thing, we can't do anything with the case until service is completed because they have to have proper notice that the case has been served, so here's what we're going to do. And again, the court does appreciate that COVID adds an extra layer to getting these types of civil matters completed, so we're going to adjourn this to complete service. Let's also take a look at the affidavit. Okay. Okay, the service on this is good until April 16. So here's what we're going to do. We can put this out to April 9, so hopefully that'll give your company plenty of opportunity and time to look at your options for service. Okay, again, it's at 9:30 a.m. Okay, the next thing that we have is the Don Dickey, and the court does have your evidence submitted. And it appears, unless you can give us an update, it appears that the is there also a service concern with this one?
No, that one, Ms. Dickey has been served.
Okay, did your office submit the proof of service?
I do believe so, Your Honor. I'm trying to pull that email up now as we speak.
Okay, no, we're gonna flip through everything again, because it might be that it's all in one packet, it's in the one packet, so let's flip through everything.
Yeah, we did submit a proof of service for Ms. Dickey. She was served on like 2/18/21. I'm reading that correctly.
Okay. Okay, sir, be advised, at this time, we do not have the proof of service in the file. We're going through everything. Was it a process server, or how did you complete service, if you know?
We used the process server, and I believe that they were emailed to the courts earlier this week, if I'm not mistaken.
And stand by. What was that date again?
The date of service was, I'm sorry, and this is for Vicky. It looks like she signed it 2/17, and it was signed by the server on 2/18/21.
Okay, and to your knowledge, how was the proof of service forwarded?
I'm sorry, it's some background noise, Your Honor.
To your knowledge, how was the proof of service forwarded to the court?
Via email, if I'm not mistaken. As well as the server would have, took it down to the court, but I believe that it was also submitted via email. I'm trying to pull up the email here. The email date that was sent out to you by Pamela Formaduro.
Okay, we might have to follow up on that. By any chance, do you have your copy or your version of the proof of service available, or maybe you can email it to us?
Yes, Your Honor, I do. If you give me the email address, I can send that over to you.
Okay, let me know when you're ready.
I'm ready.
It is Aaron, Aaron, dot Sanford, SANFORD, at 36T like Tom, H like Henry, District Court, that's all spelled out, .org.
I will submit this one as well as the rest of the services that we may have regarding the cases.
Okay, thanks. Okay, thank you so much. Tell you what, it's fun. We're gonna go through these other ones, and it looks like there's also a proof, you still need the proof of service for Glenn. The proofs are here, the evidence packet is here. We just need the proof of service for Glenn,
Okay.
and then safety for Antonio Green.
The case for Antonio Green, we were looking to dismiss as he vacated the property.
So you're dismissing Green.
Yes.
Okay, thank you, sir, for the update.
And I just sent out the email for proof of service
Thank you, sir.
for Ms. Dickey as well as Ms. Green.
Okay, court is in receipt of the proof of service for Dickey and for Glenn. All right, tell you what, let's start with. Might need a minimum judgment form, which I need. Okay, we do have proofs of service for the remaining two cases. The first one we have is for Julelia Glenn, and the court is in receipt of the paperwork, including the lease agreement. And your office is claiming $6,000 in damages.
Yes, Your Honor.
Okay, let me ask you this, sir, just to clarify, what's the status of Ms. Glenn still at the property, or is she no longer tenant at the property?
Your Honor, I can hear you.
Is Ms. Glenn still a tenant, or has Ms. Glenn vacated the property?
Ms. Glenn has not vacated the property, Your Honor.
Okay, well, sir, okay, in which case I think we kind of need to go through these other ones, because here's the concern. If it is the case that, again, kind of like it touches on the first case where the other part where the Davises were here, small claims is not a venue available unless or until the tenant is out of the property.
Okay, and Your Honor, that's going to be the case for the remaining, for the case for Dickey as well as for Glenn.
Okay, because also if it is the case that, well, the upside is that you have proof of service. The downside is, again, these cases are not right, because if those tenants are still at the property, you don't know where you stand, you don't know what you want, what you need to claim in these cases unless or until the tenant is out of the property. Small claims does not become, doesn't have jurisdiction unless or until the landlord-tenant relationship is over.
Understood,
Okay.
Your Honor.
Okay, so here's what we're going to do. I mean, otherwise, everything is good. I mean, the evidence packet is terrific. Thank you so much for being able to, forward or get to us the proof of service. Functionally, everything is very good. It's just that the timing is just something that your office will want to re-examine so that they know when it's time to file in small claims.
Okay, I'll definitely deliver the message.
And again, as a practical matter, I think in one of these, the court just saw it very briefly. One of these is where apparently the dollar amount, at least at the time of the filing, had already exceeded the $6,000.
Yes.
Yeah, if it's over that, here's the thing. Again, your office may need to re-examine whether or not if they simply want to do everything in small claims, or if they truly want to pursue the dollar amount that's in arrears or whatever the damages are. Because if it's over $6,000, legal action is still available, but it would be in the general civil division of this court.
No, understood, Your Honor. I believe that when they filed, they were more so looking to try to rectify something because it had been so long without receiving anything during the time period. So they were trying to get something going and then possibly get into some negotiations if we could work with the tenants on that end.
Yeah, just be aware that, if that is the course of action that your office wishes to pursue, this court can't stop anyone from filing lawsuits. It's just that unless it just depends on whether or not if that's how they want to spend their time, because filing in small claims, basically these are going to get dismissed, because if it's premature, they're going to get dismissed.
Understood.
So again, the court's not fussing at you. I'm not shooting the messenger. It's just that they may need to examine how they want to proceed if they want to pursue any kind of action, and what they want their result to be. They need to sit down with an attorney and speak with an attorney who can help guide them on what's the most appropriate, what's a more feasible way of getting things done. This court cannot give advice. Basically, they're just going to get dismissed.
Okay.
Okay, I think that concludes everything at this time, sir. Mr. Kennedy, thank you, Mr. Marshall, thank you so much. We appreciate your patience and your time. And, again, I think we've addressed just about everything. And you should be receiving copies of all of the paperwork shortly at the address that was submitted with the filing.
All right, thank you, Your Honor.
Okay, thank you, sir. Take care, sir.